This principle discloses on the prosecuting and investigating authorities the duty and the obligation to disclose material within its possession. And certainly this applies to exculpatory material. Now, that's not necessarily a right contained under your Criminal Evidence Act, your Criminal Procedure Act or your Evidence Act, I apologise. And it's certainly not a matter which is contained in the International Crimes Tribunals Act. So the first point that we look at is ensuring that the parties are equal before the court. If an accused is denied access to an investigative file, if he is denied access to documents, and if he is denied access to the material that goes to establish the charges against him or the allegations against him, the equality of arms principle has not been complied with. This relates equally to proceedings as to custody as it does to trial. The next point that I would like to address is the independence and impartiality of the tribunal. I would just like to clarify, whenever I mention the word tribunal, I'm not talking about any tribunal in particular, I'm talking about courts in the general sense. The concept of an independent and impartial tribunal is enshrined in all human rights treaties, and it is a matter which Bangladesh is required to comply with as a state party to the covenant. It is required to comply with this under their general obligations under international law. The first point, we must distinguish what we mean by independence and what we mean by impartiality. Independence must be institutional and functional. The independence of a tribunal may be summarised into 3 rules. 1, it must function independently of the executive, and it must base its decisions on its own free will, its own free opinion about the facts and the legal grounds. There must be guarantees to enable the tribunal to act independently. This may well be due to the manner of appointment of judges and the manner in which judges can be removed, their term of office, and matters such as this. It must also be remembered that any semblance of dependence must be avoided. The appearance of independence is an objective test. And again, this returns back to the maximum that we mentioned earlier, that justice must not only be done, it must be seen to be done. Moving on to impartiality. Impartiality denotes an absence of bias or prejudice. Impartiality may be established under 2 separate tests, objective and subjective. Subjective impartiality is difficult as it requires actual proof of bias. Objective impartiality, once again, returns back to the semblance of partiality. If there is any suggestion that an individual judge is lacking in impartiality, he must recuse himself. We can look if a particular judge has made public statements as to particular trials or particular kinds of trials, war crimes trials in particular. If a particular judge has made comment, has exposed himself, then the question is, how can he possibly remain impartial when sitting on a trial? So, an individual judge must not be biased with regards to the decision he takes, or the tribunal in regard to the decision they take. They must not allow themselves to be influenced by popular feeling or by outside pressure. And it must base its opinions on objective arguments on grounds that have been put forward at trial and nothing else. The importance in relation to impartiality is it's not something, once it's been raised, that the court can just forget or overlook or dismiss. Once it's been raised, it has to be investigated unless it is devoid of merit. That means if counsel for the defence raises that a particular judge is impartial, the tribunal is required to consider whether that allegation is made out. It cannot merely dismiss it. The next point I'd like to raise, and I'll raise it very briefly, is the reasonable time requirement. Now, the reasonable time requirement falls in two respects. First of all, if a person is in custody, the length of period by which they can reasonably be detained, but also the process in totality, irrespective of whether a person is detained, has to be conducted within a reasonable time. The reason for this is so that individuals do not lie under a charge for too long and that the charge is determined. Now, I know that causes some difficulties. In certain cases that we are talking about, individuals have not been charged. The question is, are they entitled to the protection of the reasonable time requirement, notwithstanding no charges being brought? The answer to that is yes, of course, because a charge has to be given a wider meaning than a formal charge. It is recognised as being the official notification by the authorities that you are under suspicion or you are under investigation for a criminal act. The fact that individuals have been detained under the authority of the tribunal, and in this respect I am talking about the International Crimes Tribunal, is sufficient for time to start. And the manner in which you consider the reasonable time requirement is, first of all, you look at when time starts, as I just mentioned. You look at when time ends, which is the final conclusion of the proceedings, and then you must determine whether that period is reasonable. In order to do that, you have to consider the conduct of the authorities, whether the proceedings have been expedited, whether there has been unnecessary delay, whether the defence have contributed to the length of proceedings, because we cannot complain of something of which we are the architect, of course. A response often given by the state is that the administrative backlog of cases is such that these things take time. We don't have enough judges, we don't have enough prosecutors, we don't have sufficient funding. That is not enough. A state is required to organise itself so that it can meet its international obligations, and in this respect they are required to organise their court system so that they can process cases in an expedited manner, particularly if a person is in custody. Now, the reasonable time requirement is a right that is completely separate from the fairness of the proceedings. In order to make the argument, there does not have to be any prejudice to the fairness of the proceedings, as it is a standalone right. In the paper I set out in more detail the requirements, and I won't go through them now because I'd like to move on to the other matters, and I'd like to give you all the opportunity to ask questions at the end. So now we come on to the minimum defence rights in a criminal trial. You'll note that under Article 14.3 of the International Covenant, a number of rights are set out. This is not an exhaustive list. This is not a list of aspirations. These are not illusory rights. These are important minimum standards for a criminal trial, irrespective of whether it's a war crimes trial, a domestic criminal trial, or any other kind of criminal trial. I've set out a number of requirements in this respect. First of all, information to the accused. Again, I appreciate that this is a matter of some importance because an individual has to be informed of the nature of the allegations against him. The reason for this is he has to be put in an opportunity so that he can start to prepare his defence. He has to be able to answer the allegations. If he's not provided with that information, he is simply unable to commence his defence. The information to the accused must be delivered promptly. Now, under international standards, there's no set time period for what prompt is, but I think you can use your imagination that 9-10 months is probably not particularly prompt. It has to be in a language which he understands. Not a language he prefers, but a language he understands.